Welcome to the Fresh Start webinar series with Mike Wallace. Today we are going to cover collection lawsuits. Mike, welcome to the webinar.
Thank you, Jordan. I appreciate you hosting this today.
Yes, my pleasure. I'm looking forward to learning more about what you do and how you help people by providing the services that you do. So, Mike, let's start with the basis of collection lawsuits. And before we do that, I just want to invite our listeners to please take notes. If there's anything Mike touches upon that you need more clarity on or that you would like to ask him about later, the phone number is on the screen. You can reach him at 800-867-1583. And what Mike does is once you call that number, he will actually schedule a consultation with you. So he wants to hear about your particular needs or concerns. And even if you're not sure how he will work with you, I want to encourage you just to go ahead and give him a call and just let him guide you through your, again, particular needs or questions regarding collection lawsuits or really any pressing financial matters that you may have that may require litigation or this type of service. So Mike, explain to us, what is a collection lawsuit?
Jordan, a collection lawsuit is a state court suit that's brought against a debtor for a debt owed to a creditor, or in some cases a third-party junk debt buyer who's purchased the debt has actually filed a lawsuit in state court. It can be at the JP level, or it can be at the state court, which would be district court or county court at law level.
Okay, so what happens when a collection lawsuit has been filed against you?
Once a collection lawsuit's been filed in state court, then the creditor will attempt to have a copy of the lawsuit and a citation officially served on the person by a private process server, constable, or sheriff's deputy.
Okay. And what are some of the, or who are some of the creditors that file these collection lawsuits?
Well, as I mentioned previously, a lot of what we refer to as junk debt buyers file a lot of collection lawsuits. And some of the typical junk debt buyers are companies Portfolio Recovery, CACH, LLC, Midland Funding, and there are several others who buy a debt and then turn around and file a lawsuit on it. Other collection lawsuits are filed primarily by the credit card companies, and some examples of that would be GE Capital Bank, Bank of America, Citi, Synchrony Bank, American Express, Discover, just your typical credit card holders.
Okay, so you probably touched upon that, but can you explain a little bit more about what is a junk debt buyer?
A junk debt buyer is a company that buys old debts, and typically they are debts associated with credit cards. So most people who get served with suit papers, they're thinking, well, I never had a debt with this person. So a lot of times they're kind of blindsided. They're thinking to themselves, well, I don't owe this person. Well, they potentially do, because what's happened is that junk debt buyer has bought the account from, let's just say, Discover. So Discover sells some old accounts, the junk debt buyer buys them, and typically when they buy these debts, they buy them for pennies on a dollar.
So what should I do if I'm served with a collection lawsuit?
A lot of times people ignore collection lawsuits, and that's the last thing that you want to do. Creditors file collection lawsuits knowing that in the overwhelming number of cases the lawsuit will not be answered. So they're banking on the fact that you're not going to file an answer to the lawsuit. And statistics show that on average about 90% of all collection lawsuits go unanswered. This plays right into the mode of operation for creditors who file collection lawsuits. They want the process to be easy. So when an answer's not filed to a collection lawsuit, then a default judgment's entered against the debtor. And so if you've been served with a collection lawsuit, it's very important that you contact me or an experienced or another experienced attorney to consult with regarding the action that should be taken related to that collection lawsuit.
So what if a default judgment is taken?
Most people who are served with collection lawsuits take the position that the creditor cannot get blood out of a turnip, as the old adage goes. And a lot of times that might be true, but court judgments can haunt you for a lifetime. In fact, I saw a recent posting for a judgment sale in Lufkin, Texas, for a judgment that was entered in 2007. And so the judgment creditor discovered that the debtor had inherited property in Angelina County from a relative, and they were executing on the judgment. That means the inherited property was being sold on the courthouse steps to satisfy the judgment. Inherited real property is one type of property that generally a judgment creditor can reach because it's what we call non-exempt property. And that's why it's necessary to seek professional advice if you are served with a collection lawsuit. You don't want the creditor going after non-exempt property and executing on the judgment.
Right. So Mike, how quickly must I act if I'm served with a collection lawsuit?
Collection lawsuits, if they're for an amount less than $10,000, are often filed in Justice of the Peace courts. So if the suit's filed in a Justice of the Peace court, then you have a very short period of time to file an official response to the suit. A citation from Justice Court gives you generally until the Monday following the expiration of 10 days to file an answer. In other words, once you're served with the papers, then the Monday following the expiration of 10 days after that, the answer's due. So it's a very short fuse. It's important that you act very quickly in that instance. And then if the suit's filed in a county court at law or a district court, you have until the Monday following the expiration of 21 days to file an answer. But in both instances, you've got to act upon it and not ignore the fact that you've been served with official papers.
So what are some of the things that a judgment creditor can do to collect on a judgment taken against a person?
Well, a lot of times the creditor in the collection lawsuit will serve what's known as request for admission with the suit papers. And so if an answer is filed and no response is filed to the request for admission, then the creditor uses the lack of a response to the request as a basis for moving for a default judgment. And so a failure to respond to a request for admission under the law is a deemed admission. So then they take those deemed admissions and they use them in order to move forward and obtain a judgment against the person.
Wow. So what if an answer is filed?
If an answer is filed, first, it keeps the creditor from taking a default judgment. In addition, sometimes there's a valid defense to a collection lawsuit. For example, the suit may be barred by the statute of limitations. When there's not a valid defense to the suit, an answer still allows for a period of time to potentially negotiate a settlement of the suit or time to put the debtor in a bankruptcy. Keep in mind that if a default judgment or post-answer judgment is taken, that the amount owed, the judgment amount, accrues interest until the judgment is satisfied. So judgments also show up on credit reports as public records and are extremely detrimental to the debtor's creditworthiness. So any lender looking at the possibility of loaning money to a judgment debtor is most likely not going to be willing to take the risk with an unpaid judgment that's hanging over the debtor's head. Also, and I failed to mention this before, is that in a situation where a judgment's taken against a person, the creditor can file what's known as an abstract of judgment in any county that that person owns real property. So an abstract of judgment creates a judgment lien on any non-exempt real property that the judgment debtor may own in the county. And as mentioned earlier, if you inherit real property after an abstract of judgment's filed, then a lien is created on that property. So judgment creditors don't have a valid lien on homestead property in the state of Texas because our homestead law protects against it, but the abstract creates a cloud on the title. This means that if you go to sell the homestead property, the title company is going to require a partial release of lien from the judgment creditor. And there's a process to accomplish this, but it's time-consuming and somewhat burdensome if you're trying to make a quick sale. And so judgment creditors can also garnish bank accounts. If they learn that you have money in a bank account, they'll garnish the money, and you will not have notice of the garnishment until after the bank account has been frozen. So in this situation, the judgment creditor can also serve post-judgment discovery on you to ascertain if you have any non-exempt assets that can be executed upon.
My goodness. So is there any way to avoid or head off a collection lawsuit?
The general belief a lot of times for a debtor is to think that if they ignore a creditor long enough that the debt will be charged off and they'll be in the clear from a collection lawsuit. Actually, collection lawsuits are invited by ignoring the creditor and allowing the debt to be charged off, because that's when the junk debt buyer then buys the debt, starts becoming aggressive in attempting to collect the debt. So it's important to be proactive in dealing with the debt before it's charged off. Sometimes this, of course, means that it's in the best interest of the debtor to get a fresh start by discharging the debt in a bankruptcy filing.
Right. Well, Mike, this is great. So tell me just briefly, how can someone move forward with you if they get a collection lawsuit filed against them or they're concerned about it? How do you work with people?
Jordan, it's very important that that person just pick up the telephone, give me a call. If I'm not available, they can leave me a message and I'll get right back with them. And I'll give them a game plan for how to deal with that collection lawsuit. Certainly, we're not going to ignore it, so we're going to take some action. And that just depends, what action we take just depends upon the person's individual circumstances. So very important that they give me a call, Jordan, and we visit about their particular circumstances.
Okay, great. And Mike, on your website, under the About section, you talk a little bit about 3 things that, just in closing, I want to know if you will touch upon. You talk about finishing strong, investing in what you care about, and leaving a legacy. Would you expound on those 3 areas and just tell me how they dovetail with your practice and your own belief system?
Well, Jordan, based on what I do, bankruptcy work and helping people with financial burdens, it's important for people to realize that sometimes bad things happen financially to people. Excuse me. And what I want them to understand is that with respect to finances, it's important that they get on the right track. So it's not necessarily how they have begun the race of life with respect to their finances, but it's important about how they finish. So I want to give them an opportunity to get that fresh start. That's why we call this the Fresh Start series, because that's what I'm ultimately trying to do, is to get the person to a point where they can get a fresh start financially. And so once that happens, then the person can then invest in what they care about. When they're not burdened by financial issues, then they can invest in things that they care about. They can also leave a legacy. And I know it's difficult for people going through financial crisis to understand that there's life after bankruptcy, but there is. One of the people that I use in my practice is Dave Ramsey, and Dave's story is he, as a young man, he was involved in the real estate business, and he unfortunately went broke and had to file for personal bankruptcy protection. But Dave is an extremely successful businessman now, and he helps people learn to do the right thing with respect to their finances. And part of that, Jordan, is being able to leave a legacy financially for children and grandchildren. So there's that possibility, even though someone might have gone through a bankruptcy. There's lots of people that are wildly successful in the world's eyes that have been through a bankruptcy filing.
And so with that said, Mike, tell me about the region that you serve. There's some cities on the screen, but are you exclusive to the cities that are listed?
No, in addition to those, Jordan, there would be others. I would say that any city in between any of those or near the surrounding area, even especially over east of Nacogdoches and Lufkin, over west and south of Palestine, there's lots of areas in between those cities that are shown on the screen that I serve. So if you got a question about your financial situation and you're unsure whether or not I can help you, I just suggest you give me a call. If you're outside of the territory I serve, then I'll refer you on to someone else who can help you.
Okay, great. Well, wonderful. Mike, thank you so much for this information and another great installment in the Fresh Start webinar series.
Thank you, Jordan, for hosting.
You're welcome. Thank you for joining us today on the Fresh Start webinar series with Mike Wallace. I would encourage you to give him a call. If you call Mike's office, chances are you are going to reach him personally. If you do not get him on the phone, you will get his voicemail, and he will be the one returning your phone call. So you won't have to worry about calling Mike's office and getting lost in a system or getting shuffled from one person to another, that you will actually get an opportunity to speak with Mike in person. So I want to encourage you to visit the website and to read the blogs and to send any questions that you may have via the website if that's your way of a preference of contacting. More than anything, Mike Wallace is here as a service to you, and we look forward to connecting with you in the next webinar.